In today's lecture, we're going to be looking at Chapter 2 of the text, focusing on the federal courts. We talked about that briefly in the last lecture. We're also going to talk more specifically about federal courts, looking at the Supreme Court in 2 weeks after we watch a documentary next week about the Supreme Court member. As we talked about before, there's the dual system with the federal court always superseding the local courts. Within a court proceeding, it's based on the court's jurisdiction over a case. That could happen based on the geographical location of a particular offense taking place. Also, within that geographical area, they will have specific venues in which to hear the cases. Those are typically courthouses for those areas. The jurisdiction also could be based on the subject matter of a case. Some courts hear all the cases of a particular type in a particular area. And then one of the last issues, personal jurisdiction is gained when an individual commits an offense that is under the purview of the court. So then it gives the court personal jurisdiction over that individual. There's also the issue of hierarchical jurisdiction. There's a couple different ways of looking at that. Sometimes you can have concurrent jurisdiction where multiple jurisdictions have say in a particular case. And again, with the federal courts superseding the local courts, they can assume jurisdiction, or they can allow a local court to try a particular case. It's also in reference to whether or not talking about the original trial happening, whether it's a civil or criminal trial versus the appellate level. So is the case being reviewed, or is it actually being tried? So those are important things to note when looking at where in where in the court system a particular trial will sort of slot in. The federal courts were established in Article 3 of the Constitution. Then, as we've had a need to further expand and elaborate on that, we've had a few major increases in the system. So the Supreme Court is established by the and the ability of the country to create courts established by Article 3 of the Constitution. But then we have these various acts, mainly the Judiciary Act of 1789, and later the Court of Appeals Act of 1891, that established a lot of the courts that we have in place today. So what we have today, district courts, establishing the Judiciary Act of 1789 established the districts. It also established what judges at the time would overhear those issues, and also establishing the issues of jurisdiction. We've also seen the idea of judicial review come into application in the American government system, where the courts will review actions of government to make sure that they are constitutional. There was some spirited back and forth between various aspects and new branches of the government when it was first developed in the late 18th century. The next major addition to the court system that we have is through the Court of Appeals Act of 1891, which established the federal courts of appeals below the Supreme Court. The Supreme Court is and always was a court of appeal, but this established an intermediate system of courts to hear a lot of the cases that were trivial or petty compared to some of the other things the Supreme Court was deciding. In 1968, we see the development of U.S. magistrate judges, and again, it's the same principle as the establishment of the appeal system. They were trying to reduce the burden and the workload from the district court judges. These judges, unlike the other appointed federal judges, are not lifetime terms. They're usually 8 or 4 years, depending on what's happening. They don't between what the role is. They don't do trial duties. It's sort of the pre-trial things that we talked about, allowing people to enter pleas, doing those initial appearances, motions, and things like that. And these judges hear almost 1.2 million cases per year. There are 574 full-time magistrates and 40 part-time. So, looking at 600 people that are reviewing 1.2 million cases per year. Above them in the system of courts is the district courts, district court judges within the United States and various territories. We have 94 districts, 89 are within the states, at least one per state. No districts can cross state lines. 677 district court judge positions, although they're not always all filled. They're appointed by the president and confirmed by the Senate to serve for life. We also have a lot of bankruptcy court judges. This is a specific sort of specialty court where those serve 14-year term. Overall, the district courts see about 91,000 criminal cases per year and about 375,000 total cases with regards to civil matters and things like that. So those are the cases that are not that not have a plea. Those are the ones that actually go to trial or go through some form of trial process where it's going to have to be reviewed by the district court as opposed to the magistrate court. Some other issues that come up with the application of the federal courts is to handle uncommon issues that come up. So applying state law to federal cases. If you have a situation where an individual from another state commits a crime in a different state than they're from, sometimes, depending on what the wishes of the defendant are, that can be held and tried in federal court, but the federal judge has to apply the state law in those cases. So they have to, the district court judges have to be very familiar with the state law from where they're practicing as well. Also, if there's disputes between two parties from different states, those would also be handled at the federal level. So again, you have to, when you're looking at jurisdiction where a case is going to be tried, you have to look at everything that could impact the jurisdiction, and then you have to look at some of the decision-making processes that go on by the mostly by the defendant and the defense attorneys, and some by the prosecution as well. So some of the things that they look at the federal level, the constitutionalization of the criminal procedure, making sure that they knew of things like cell phones. So when cell phones became these things, they had to change some laws because a dumb phone, like a flip phone, you're not going to have things like banking information. You're not going to have things like your email put into that phone. Whereas a smartphone, there's all kinds of things that have to be taken into consideration when you're doing like a police search of the phone, looking through text messages. It's much different on a dumb phone than a smartphone. Also, with advancements in having locked compartments in cars, that's something that the courts had to look at and address. Also, a big one recently is with the death penalty and its application. Looking at how states can carry that out is a big issue right now in the court system. They also look at things like discrimination law, civil rights cases. The Supreme Court just made a big decision a few months ago in 2020, basically giving workplace protections to LGBTQ community members. Before this year, it wasn't legal because the way that the courts ruled, the rule based on things that are in place, it was an acceptable practice in some social circles to discriminate against people in the workplace based on things that are beyond their control, and that was in the past only been looked at as race, and now it's expanded to other characteristics that people have that shouldn't be any kind of a basis for their employment. So look at things like that. They also look at petitions filed by prisoners, those in the correctional system, habeas corpus motions, things like that, as a way to address injustices that happens in the correctional systems. So the U.S. Court of Appeals, again, this is above the district courts. 14 circuits, 11 numbered. So some circuits only have one state, or actually just have one state. Most of them are made up of multiple states, and they hear the appeals cases arising from those areas. The root cases from the district court, federal administration changes. They could also hear appeals from state Supreme Courts. Again, we have 179 judge positions. They're not necessarily always all filled. They're trying to be filled for the most part. They're appointed by the president and confirmed by the Senate. You typically are going to have a three-judge panel from all the members of that circuit court, of that appellate circuit court. But if you don't like the way that three-judge panel rules, you can make a motion for what's called an en banc hearing, which is going to have all the judges on that circuit, which is typically 7, would then make if they agree to hear the case, they would then make a ruling that could overrule or confirm the three-judge panel ruling. Overall, the appeals system, federal level hears about 56,000 cases per year. And for most cases, it is the case of the court of last resort. They don't go to the Supreme Court. The Supreme Court only hears a very small percentage of the cases that are applied to them. So again, the U.S. Court of Appeals is the last stop for most cases. Those that do make it can be heard before the Supreme Court. For that to happen, 4 of the 9 members must agree to hear the case. There are 9 judges. There's a chief justice and 8 associate justices. They're appointed by the president and confirmed by the Senate. Because of a procedural change in the Senate that was actually implemented by a Democratic-led Senate, it only requires a simple majority of the Senate, so 51 out of the 100 votes, to confirm a chief justice, which has been a contentious issue in recent times. They only have original jurisdiction on a very, very small subset of cases, things arising between the United States and other countries. They might hear a case like that. Again, but other than that, very, very specific the cases where they have original jurisdiction. They do have a wide discretion of cases that they want to hear, and they can pretty much pick any case that has been decided by a U.S. appeals court. Most cases of those 56,000 cases the U.S. appeals court hears, a lot of them are petitioned to the Supreme Court after that. So the Supreme Court has a wide berth to pick from of what cases they want to do. But again, that's to do that, they have to issue a writ of certiorari, which again is based on the rule of 4, that 4 of the 9 justices have to agree to hear a case. Doesn't necessarily say which way they're voting, but 4 of 9 have to agree to hear the case. They look for cases with significance, cases that have potentially have an ability to change the way other cases are decided, but they can't like seek the cases out other than them coming from the appellate system. So if they see a case that's decided, a criminal case decided at the state level, they can't immediately pluck that case to be heard. It has to make its way through the other court levels before it can get to them. They typically only hear about 80 cases a year. Sometimes it's more, sometimes it's less, just depending on what's happening. They actually heard cases over the phone for the first time for a video conference back in May of 2020, depending on what semester you're watching this. It might be May of this year or last year. So they are a very small percentage of cases, and often takes them, it could take them a year or 6 months to actually issue a ruling on a case. So it's a very, very slow process. We also have specialized federal courts. The main type of that is military courts. They are held in a different standard, different burden of proof. Only open to active service members. It could be a 3 or 5 person juries of military personnel. It only requires a 2/3 majority to convict. There are automatic appeals. And the major issue with this, because they don't really have, there are crimes committed by American servicemen and men and women, and that's the bulk of what's happening in these cases. There's not too many high-profile cases. It's more during wartime. You have issues that come up. But something that's come up recently in the last 15 to 20 years is how we handle enemy combatants, non-military combatants, and what sort of rights that they have. And it's been a big issue. I'm going to link a video to that, so be sure to watch the video about how we've handled that in recent times. And then also the other specialized courts that we have are the immigration courts, part of the Department of Justice, and they're trying to do too much right now. They're overburdened, they're overworked, and the job that they do affects people in a monumental way. So there's another video linked for the immigration courts. Be sure to watch that. Be sure to review the book chapters, read the PowerPoints, and next week we'll be watching a documentary about the Supreme Court, a particular Supreme Court member.